So, 4 basic categories of estate plan documents.
Yeah. So we kind of went over that.
Yeah.
That's the will or
Right.
trust.
Yep.
The thing that gives stuff to people.
Yep.
Down to guardianship with children. If you're at the age of 18 and you're going off to college, you want to give a healthcare power of attorney to your parents or someone that you know that's going to be able to make those decisions. When you're a young adult and you start having kids, if something happens to you, you want to make sure that your kids are taken care of in the manner that you choose. Otherwise, if you don't designate guardians, the court's going to decide because they're going to take an evaluation of who's best suited to watch after this child, and the parents should be the ones that are deciding. And you want to put that in writing. You're going to have that in your will to say, hey, this person is in charge of my child.
Welcome to today's edition of the Smart Start podcast, brought to you by the Equitable Bank. I'm Tom Sattler. In today's episode, we're going to delve into the critical topic of power of attorneys and its essential role in estate planning. Today, we're joined by attorney Doug Knoff from Knoff Law LLC. With extensive experience in estate planning, Doug will provide valuable insights into the importance of having a solid estate plan, including the nuances of the power of attorney. Welcome to the Smart Start podcast, Doug.
Good to be here. Good to be
Always
here.
a pleasure. So let's talk about when should somebody start or have the conversation about getting a power of attorney for them.
Well, powers of attorney are basically part of a bigger plan. It's an estate plan that we're talking about.
Okay.
So estate plan basically consists of 4 categories of documents. You've got the will or the living trust, the thing that gives your stuff to other people upon your passing. You've got the healthcare power of attorney, the financial power of attorney, and then the living will. So the financial power of attorney is the one that says, hey, during your lifetime, if something happens or you give that person that power while you're still able to, someone else can act on your behalf regarding financial matters. The living will, or declaration to physicians as it's sometimes called, is something where you're giving end-of-life decisions in writing to your doctor, saying if you have a terminal condition or you're in a persistent vegetative state, don't use life-sustaining procedures, don't use a feeding tube.
Okay.
Those are kind of the key things where you're basically telling somebody, hey, let me die naturally. Don't waste my money keeping me alive unnecessarily. Hand in hand with that goes the healthcare power of attorney. Mm-hmm. That's the document that gives someone else the ability to make healthcare decisions on your behalf when you can no longer make those decisions. And so if you can't make those decisions, you kind of already had the conversation about what you want, but it's also giving them the ability to advocate on your behalf.
Okay. What age should somebody get a...
Well, you can get them when you're 18.
Okay.
So as soon as you turn 18, you can get one. The thing about that is when someone turns 18, a parent sometimes says, oh, I want to find out about my child who just went off to college. And they can't really do anything because they haven't been given the power by their child to make decisions on their behalf. So if you've got college-bound students that have turned 18 that are going off to college, you want them to sign a healthcare power of attorney that designates, hopefully you, if you've got that kind of relationship with your child. Otherwise, you want them to at least give that power to someone, maybe an older sibling. You can't be someone's agent unless you're 18 as well. So they can't give it to a younger sibling that's not 18. They can only give it to their parents or someone older.
So what circumstance would that happen if they were in a...
See, they're
coma?
in a car accident, coma, something where they're unable to make healthcare decisions. They're at college. Parents call. They try and find out, well, what can we do? Let's make a decision. Unless there's a healthcare power of attorney that's been activated and is on file, no one knows that that person has the authority to make those decisions. And you haven't been given that authority by the principal, the person that is the one that's giving that.
So it's beyond just you're not able to get access to them, but it's also basically no healthcare decisions can be made?
Well, the doctors would then be making the decisions to keep you alive, that kind of thing.
Okay.
If you end up being in a persistent vegetative state because you got in a really bad car accident, they can't just say, all right, pull the plug, our child is no longer with us.
Right.
Kind of a morbid thought, but that's...
Yeah, right. So I think the whole conversation, as we've been talking, we've done a couple of seminars together, and I think part of the target audience has kind of been, and really part of our demographic is a more senior audience, right?
Correct.
People who are still, maybe getting close to the retirement age, who have, what would be the first steps they should take in establishing an estate plan and or
Well, it's about
establish a
having the
power of attorney?
conversation of
Okay.
what they want to do, where they're at as far as their relations, as far as, all right, are you married? Is your spouse still living? Do you have children? Do they have children? Kind of the, all right, when you pass, what happens to your stuff? Before you pass, what happens if you need to get into a long-term care facility? Who's going to help get you there if you can't make these decisions anymore? So having a healthcare power of attorney as a child that's been designated your agent can help you get there and help them in what they're trying to do for you when you need better care.
Because that's kind of what it's almost, you're able to make your decisions in advance of those decisions having to be made.
Right.
At least it's not a fire drill.
Right. It's I've made my decisions. I've told people what I want. And I've had discussions with the people that are going to be able to advocate for me when I can't do it anymore.
Okay, so myself and my wife come in and sit down and talk to you and say, I need to have, we need to do estate planning. I'd like to establish a power of attorney for both finances and
Healthcare.
for
Yep.
healthcare. How would we start?
Well, typically a spouse is going to designate the other spouse as their primary power of attorney.
Yeah.
And it's going to be alternates after that. Do you have a child that's maybe in healthcare that you think will make better decisions than someone else as far as the healthcare decisions are concerned? And you've got another one that happens to deal with financial things that's better for the for the financial power of attorney. So you're going to make these decisions based on what you guys believe to be what's the pecking order of who's going to actually advocate for me on my behalf in the best manner possible. And to say it this way, you can make your own decisions. Your spouse can make their own decisions. Typically, those line up with each other. It's going to be easier and for one person to help make those decisions because you're probably going to be making those decisions for your spouse. Your spouse is going to be making them for you until one of you passes. Then it's kind of default to one of the children, a sibling of yours, whatever it may be.
So you're going to go down some relation line.
Right,
I mean,
right.
because if my wife and I happen to be together and there's some unfortunate accident occurs, we need to have somebody
Just as a side note, you guys are both my clients at that point. So if you tell me something, I'm going to change this so it's my neighbor and I don't want my wife to be it, I'm obligated to tell her these things.
because that's not going to happen.
Right, right. What I'm saying is you can't come to me and then try and have a little secret about
Yeah. It's a partnership.
Right. So, you guys are both going to be open books when it comes to me, and I'm going to be an open book with both of you about each other. But obviously I have confidentiality, so I'm not going to tell anyone else.
Right, gotcha. So 4 basic categories of estate plan documents.
Yeah. So we kind of went over that.
Yeah.
That's the will or trust.
Yep.
The thing that gives stuff to people,
Yep.
down to guardianship with children. If you're at the age of 18 and you're going off to college, you want to give a healthcare power of attorney to your parents or someone that you know that's going to be able to make those decisions. When you're a young adult and you start having kids, if something happens to you, you want to make sure that your kids are taken care of in the manner that you choose. Otherwise, if you don't designate guardians, the court's going to decide because they're going to take an evaluation of who's best suited to watch after this child. And the parents should be the ones that are deciding. And you want to put that in writing. You're going to have that in your will to say, hey, this person is in charge of my child.
Right. And you probably, those are conversations you will help us lead us through. Right?
I won't make the decision.
Right.
But I'll ask you to make the decision. I'll tell you, look, you need to make this decision because we need to get this done.
Right. Gotcha. What are some of the common misconceptions people have about POAs?
Powers of attorney cease upon death. So someone will come to me and say, oh, I'm their power of attorney. Oh, okay. What's going on with them? Oh, they died. Okay, so let's back that up a little. You're no longer their power of attorney. Because they've died, power of attorney ceases. That's when it comes over to a successor trustee or a personal representative. That's what we call an executor here in Wisconsin. So the successor trustee has to deal with trust issues. The personal representative has to do with things that are not part of the trust or that go to the estate.
So people think that because they have power of attorney, they can make all of the decisions with regard to their finances and healthcare. It's over as soon as somebody passes.
Yeah, all that terminates upon death.
Right. And so they should have, that's when you should have a trust.
They should have a will or a trust.
Will or trust.
Yeah.
And that will satisfy
that allows that person then to assist the principal in getting things where they need to go.
How can families ensure that their loved ones are protected through proper estate planning?
So there's a lot of different ways you can do that. A lot of it has to do with just making sure you have beneficiary designations, which is something that kind of supersedes or preempts going through probate or going to a trust. Beneficiary designations a lot of times actually have it as the trust as a beneficiary. So if you've got children, and let's say one of them has special needs where they're receiving benefits from the state, you don't want them to receive anything directly because that's going to jeopardize what they receive from the state as far as state benefits. That's when you create a special needs trust in a separate document, and you have their portion of their inheritance go to that special needs trust. That way, there's people, these companies exist that administer special needs trusts for the benefit of someone so they don't jeopardize their benefits.
This kind of speaks to, having an attorney such as yourself versus I know you can listen to the radio or you can listen to the satellite radio or whatever.
Yeah.
And you can hear about the ability to get a will right online. What's the difference between doing that and working with you?
That relies on you knowing everything you need to do to get it done properly. And most people don't know everything they need to do to get it done properly. And that's fine. If you want to give it a try, I've dealt with a lot of wills where someone has come to me and said, I did this online. And I say, okay, well, it might be found valid. It probably won't be found valid because you did X, Y, and Z wrong. And it's my job to know this stuff. And it's what I'm paid to do. Right. I've studied it. Right. It's what I've been doing for the past decade and a half. I want to help you get the results that you're looking for, and I know how to do it.
Gotcha. Many people say I don't have an estate plan.
Oh, they do. So when someone comes to me and they say that, I say, actually, what's happening is the state has one for you. Oh. It's your job to opt out of the intestate succession designation and create your own will.
Okay.
And creating a trust, in a sense, also opts out of that. If you get a trust done, you're going to have a will regardless. That will is called a pour-over will, and all that does is say, hey, anything that's not in the trust already, put it in the trust. It will also help designate any kind of child guardianship issues because the trust can't do that. The will has to do that. There'll be a special administration regarding that. But giving things happens either through a will or a trust. If it doesn't happen, then the state has this default where you have to still have a probate. The process is called intestate succession. It's going to be a formal probate, which is more expensive than if you had a will and said it's okay to do this quickly.
Yeah.
The other thing is a lot of people don't realize if you've got a couple things, just a small amount of money that needs to get into a trust or get divided to somebody because your beneficiary designations weren't there.
Yeah.
If it's less than $50,000, it's a pretty speedy process. It's called transfer by affidavit. Anything over $50,000, as far as total assets, then you have to go through probate. You have to go through the court system.
Gotcha. Do you have any, obviously confidentiality, but do you have any situations or events that come to mind that said, boy, this was the perfect example of why somebody should have estate plan or power of attorneys?
Absolutely. When it comes to wanting to disinherit someone, you've got that black sheep of the family and they don't do estate planning, that person is right there with everybody else getting their fair share. And if you feel, let's say that person has a drug problem or they've got other issues, they're going to receive their share according to the intestate succession charts. Whatever, if you've got 4 kids, it goes 4 ways, 3 kids, 3 ways. That they're going to get their share outright. But if you're concerned about their safety and them getting a large sum of money, you can create a trust to give things out to them in smaller amounts.
Okay.
The trust can also allow the trustee to determine what their needs are. And I've dealt with situations, and this is kind of how I advise people. It's if you want to make sure your kids are taken care of till they're adults, they're out of school, yeah, let's create a trust. They get their full share, 25, 30, whatever it may be. But the trustee can give them money from their share for education. If they're about to lose their house, they need a car. And this is the trustee will let them get a car. They'll buy you a Ford, not a Ferrari.
Right. I got you. Yeah. Yeah. Interesting. So what do I do to get started? How do I contact Doug Knoff?
I'm online, Knoff Law LLC. That's my, you look me up. I'm over on 76 in Blue Mountain right now, and give me a call.
Anything else you'd like to share that would be helpful to our audience?
Look, if you don't call me to help get your estate plan done, call somebody. Get it done. Even if it's not me, I'm okay with that as long as people are getting this stuff done.
Doug Knoff, thanks for joining us on the Smart Start podcast.
Thanks, Tom.